Today I want to highlight how generative AI has impacted the value of intellectual property online and how copyright laws have so far been inadequate in defending claims. Or does the likes of OpenAI, Meta and Microsoft have a point that training generative AI on authors' works is no different to learning a language from a book? So far the tech companies are winning. It's now a year since a group of US authors took the companies to court on this. Sarah Silverman, Christopher Golden and 3 others claimed that the tech firms trained their AI models on their works without acknowledgement, permission or an offer of compensation. No similar cases are filed in Australia as far as we know, but local authors are up in arms over how their works were applied to train Gen AI models, again without their permission and compensation. The online Books Free database of almost 200,000 pirated books is case in point. The compilation of this database has been described as the biggest act of copyright theft in history. In October 2020, a US researcher called Sean Prescher, who was a bit of a disillusioned games developer, created a database which also included, among them, 18,000 registered Australian titles by 15,000 authors, with works by at least 700 local authors unlawfully published online. This long list of Australian authors includes Helen Garner, Richard Flanagan, Sophia Cunningham, Trent Dalton and Thomas Keneally. Presser's original intention was to let independent researchers train AI models using the database so they weren't left behind in developing world-class Gen AI models. However, Books Free became part of a bigger database available for download on multiple sites, and it didn't take long for big tech to tap into it and train their AI models using it. It was not only authors, and I'll give a bit of a media perspective here. Online news sites discovered that their content had been used to train these models. In December last year, the New York Times sued OpenAI and Microsoft for copyright infringement, saying their chatbots were now competing with the news outlet as a source of reliable information. They want the tech firms to pay billions of dollars in damages. So we've got all these cases kind of mounting up, particularly in the US courts. The litigation has grown. In April, the Chicago Tribune, New York Daily News and 6 others announced they were suing OpenAI and Microsoft. One particularly worrying claim is that big tech's use of authors and journalists' material goes beyond training generative AI models to blatantly reproducing their copyright content. And of course, when we talk about reproducing copyright content, we're talking about those people being denied income from their works. We also had the Centre for Investigative Journalism involved in this. It quoted research that found nearly 60% of the responses provided by their GPT 3.5 chatbots contained some form of plagiarised content, and over 45% contained text that was identical to pre-existing content. In the US, some 8,500 authors have signed an Authors Guild letter demanding that the big tech firms cease using their material to train generative AI models. Unfortunately, weaker US law is being used to decide these copyright infringements. Copyright's really hard to prove in these cases. But it applies in the US because that's where these models are trained and that's where the law therefore is claimed to be broken. There's a relatively low level of copyright protection under the US, what they call the US Fair Use provisions. But then we've got Europe coming into the mix soon. Expect Europe to fire up on this topic once its AI Act comes into force in August. Its level playing field tenet seeks to prevent the tech companies hiding behind these weaker laws. They may be required to comply with EU copyright law regardless. We will see, because I guess there'll be jurisdictional disputes around that. As for Australia, it's been slow off the block in tackling the generative AI threat to copyright. Fortunately, some activity is underway. Following a series of roundtables last year, the federal government in February formed an Attorney General's Copyright and Artificial Intelligence Reference Group. In April, it formed a steering committee of industrial representatives who will put together policy proposals for reform in this country. But you can see it's a fairly long process if we're just at that structural case and going into looking at what these proposals might be. The May federal budget, including $1.2 million over 12 months, the Attorney General's Office to review the application of copyright to AI, it will fund a dedicated AI and copyright law team. It is understood the initial focus will be copyright as inputs for AI systems, that is, copyright related to training AI models. It's understood that work by the steering committee later will focus on AI outputs, copyright infringements resulting from the content generated by AI in its output. Identifying a copyright infringement can be complex. Training an AI system involves inputting a massive amount of information that the AI system draws upon to provide answers. Your information may be hard to identify as copied because, as you know, with the output of generative AI, ChatGPT, you may not know where some of the information comes from. Now, you might ask, why have I included an AI-generated picture of a Vitamizer of fruit and its output in this? Well, it's obviously generative AI is trained with machine learning, but just think of it as a Vitamizer, if you like. AI Gen model digitally vitamizes human knowledge, and when you ask a question, it spews out an answer which I'm going to call an information smoothie. Identifying that your copyright is infringed could be as hard as identifying individual slices of orange in the Vitamizer, which might have some proprietary genetically modified thing that you've patented. But how would you identify it's there in the Vitamizer after a minute of mixing? And that is the problem for proving copyright infringements in these early phases. It's good that the Attorney General's Office is moving on this, but just getting these structures in place is a slow response when compared to the speed that tech firms are developing GPT models. It seems legal cases are yet to be filed in Australia on these issues. Meanwhile, the tech firms are getting really confident now. Last year, Meta confirmed it had for years been publicly sharing photos and text from Facebook and Instagram to train its Llama generative AI models. Australian Arts Law Centre points out that its members, artists, share their art through social media. So the impact is that artists out there, they go online, they put up their artworks for sale on that, but then Meta says it's got the right to use those artworks in its mix of training AI models. Unfortunately, Australian users cannot opt out of their Facebook and Instagram posts being scooped up in this way. In contrast, European and UK users can submit an opt-out form to be excluded as of June 26 this year. The concession followed complaints by the European Centre for Digital Rights, who say Meta's actions infringed Europe's General Data Protection Regulation, or GDPR. Hopefully, changes to the Australian privacy law in August will address this through provisions that offer similar rights to the GDPR, but we'll have to see. But certainly, our citizens aren't on an equal footing with citizens in Europe in being able to opt out of their stuff being collected for generative AI use. In general, the Australian government needs to move quickly in both protecting privacy and copyright and access as well. That includes making up its mind as to how copyright is to operate in the generative AI age. Are we going to tighten law or allow case law to decide how it applies to generative AI, or accede to legal changes that Big Tech describes as modernisation code for relaxing Australian law to suit their particular interests? Our current response seems slow and ambiguous. Meanwhile, generative AI developers can do what they like and the momentum is with them. Europe's diligence in tackling these issues hopefully will provide some guidance. Meanwhile, the litigation by US author Sarah Silverman and fellow authors against OpenAI has been failing. The US judge said the authors failed to prove economic injury and that there was a substantial similarity between their copyrighted works and what generative AI produced. The legal action against Meta has been heading in a similar direction. The New York Times' action against OpenAI and Microsoft is turning messy as well. The paper is reportedly fighting a request for OpenAI to turn over journalists' notebooks and interview notes from stories they claim were used to train generative AI models. And that's a very difficult thing for journalists to do. But it's part of the discovery process in that case. There is some good news. It seems the likes of OpenAI, Meta and Microsoft are vulnerable for not asking permission to use copyrighted material for training these models in the first place. You might remember that they just took the Books3 database and used it. There wasn't any real consultation. And I want to come back to that because it's a really important point. This may not, of course, lead to the payout proponents were seeking, but the what I'm going to argue here is copyright's not the only way of dealing with this. In fact, it mightn't be the most successful way of dealing with this. I am told that evidence of Gen AI models regurgitating recognised parts of copyright work in Australia represents infringements under Australia's stronger law, but we'll have to wait and see if these emerge. So that's when the output from generative AI actually really does look like in a big slab of works being copied or whatever. But no one is holding out for governments to act on this. So what have we seen happen because of this kind of lack of confidence that the copyright law can be enforced? We've seen several media groups move quickly to do deals with the Gen AI developers rather than take them to court. It's a case of if you can't beat them, join them. This is understandable in Australia, where agreements between the big tech companies and media organisations forged under the News Media Bargaining Code in 2021 expired this year. Despite the rhetoric and public advocacy around renewing the code, the federal government has not yet forced the tech firms to renew agreements forged under the previous government. That was done by Josh Frydenberg, you might remember, in discussions with Mark Zuckerberg, and that took place back in 2021, around that time. So what we've seen is like this statement: News Corporation signing a multi-million-dollar deal with OpenAI and CEO Sam Altman in May. OpenAI can regurgitate News Corp content in response to user questions using both current and archived content. News Corp will share journalistic expertise with OpenAI. So you've got one group of publications going to court, you've got another group saying what we're going to do is do deals and get some money out of this by going in league with the tech companies. So in this particular deal, publications that are part of it include the Wall Street Journal, the Times, Sunday Times in the UK, New York Post, The Australian, news.com.au, the Daily Telegraph, the Courier Mail, the Advertiser and Herald Sun. Advertising and marketing isn't explicitly mentioned in that agreement up there, but it could become part of any deal as their partnership continues, which they're hoping it will. Payments were not explicitly quoted, but the Saturday paper estimated incredible payments of News Corp of about $378 million over a 5-year period for this arrangement. Overseas, Fox Media, The Atlantic and Financial Times also forged deals with OpenAI. As I've said, we have other groups of publications which have opted to sue generative AI developments. There's also the hedge fund Alden Global Capital, whose newspapers include the Chicago Tribune, the Denver Post, the Boston Herald, the Orlando Sentinel, and publishers Intercept, Raw Story and Alternet. A third group of media organisations have sought simply to block the Gen AI developers from accessing their content, such as CNN, Reuters, The Guardian and the BBC. Australian Financial Review reported last month that Nine Entertainment was considering blocking access to its content as well. So that's a third way that the media companies have been approaching this. Whereas News Corp gains millions from its deal with OpenAI, the ABC, for example, has lost millions from not forging a similar deal. The News Media Bargaining Code reportedly allowed the ABC to employ 60 journalists and support staff and was worth, according to reports, around $30 million a year. That's gone with the end of the bargaining code, with its expiry. Same applies to other beneficiaries, including, as I mentioned, Nine Entertainment, Seven West Media, The Guardian, 84 outlets from Country Press, Australia. Overall, Google and Meta reportedly paid out $200 million to Australian media outlets annually while the code was in place. It must therefore be tempting for media organisations feeling the pinch to still consider forging these agreements with big tech. But there's been plenty of pieces written around suggesting these deals would compromise independent reporting, particularly reporting on the companies that they are in partnership with. So, ensuring the law is updated to protect copyright and privacy is a massive challenge in this new age, and there's lots of money and effort and court proceedings still entrained in this process. But it goes beyond that, and this is where I say copyright law is not really the end of this. At the very least, AI developers should be consulting with content owners and forging agreements to use their material commercially rather than simply plundering their works. So what I'm saying here, it's not a question of proving copyright breach. It's more saying, if you're an AI developer and you want to use certain text as part of your model, talk to the company that actually owns and has done the IP around it, that owns the intellectual property, reach an agreement with them, but a loose agreement, if you like, that, but don't just simply take their works, particularly in the case of those books 3, pirated works, without any recourse for the authors, without any compensation, without any discussion with them. And that's how the tech companies tended to work. I'm hoping at the end of the day that this can be sorted out amicably and there's some acknowledgement for all these people, not just authors, but we're talking about artists, we're talking about musical composers, we're talking about anyone in any of these streams of media that have been impacted. One hopes that the intellectual property rights of authors, journalists, musicians, artists and photographers isn't sacrificed in this new era, that they have a means to still actually make an income. Ditto when it comes to privacy rights. Thank you very much.